In part 1 of the video, I discussed the importance of setting out the parties' objectives and intentions for the proposed collaboration before entering into negotiations. In the second part of the video, I will address the importance of recording the parties' intentions, how to do so, and the importance of correctly classifying the proposed agreement. I always recommend that parties lay down in writing their intentions for the collaboration. One way of doing this will be in the minutes of the negotiations about the collaboration. This serves two useful purposes. If the parties are clear about their intentions, they may find it easier to establish the type of collaboration that they are looking for and to correctly classify that collaboration. They may also incorporate their intentions in the recitals to their agreement. That part of the agreement which immediately follows the names of the parties and precedes the body of the agreement. Parties are well advised to record their intentions in an extensive recital. Under Dutch law, the principle of reasonableness and fairness dictates that the legal consequences of an agreement are not solely defined by the written text of their agreement, but also by the reasonable intentions. If the exact gist of the agreement is not clear due to imprecise use of the language or it being open to more than one interpretation, the parties' intentions may be inferred from the recitals. Please note that international agreements are not always governed by the laws of the Netherlands. Under common law, the recitals tend not to form part of the agreement. It is advisable to include a clause in the agreement which expressly stipulates that the recitals are part of the agreement, if parties wish to bind each other to them. If the parties' intentions are clear, the sensible thing to do would be to retain a contract lawyer and seek their advice on which type of collaboration best serves the parties' intentions and the legal classification of the agreement. Putting the correct legal name on an agreement or contract is important in that it will help determine within which legal parameters the document is to be subjected to review. Both parties have an interest in knowing what regulatory provisions apply to the agreement, as this allows them to determine which provisions may be left out of the contract if they don't want them to apply to the contract. Whether or not mandatory law applies, for example, also depends on the classification of the agreement. Mandatory rules do not allow for derogation by the parties. The obligation to pay goodwill compensation is one example that comes to mind. The Dutch Civil Code has rules providing for mandatory payment of goodwill compensation in agency and franchise contracts. The presence or absence of a mandatory rule imposing a compensation for goodwill tends to steer parties towards a particular sales channels, be it distribution, agency, or franchise. Determining applicable law is another element that may be crucially affected by the classification of an agreement. I will delve into this matter in another video. In this episode, I looked into the best ways of choosing the type of collaboration and the importance of correctly classifying the agreement or contract that you want to enter into. In the next episode, I will come up with some pointers to help you get to grips with negotiations for an agreement. See you next time.